Thank you very much. Good afternoon. Thank you for the invitation, Professor Diurni, Professor Amodio. Really happy to be here with you and had the opportunity to discuss one of the topics that, in my opinion, is absolutely fascinating today, because as artificial intelligence expands, the artificial intelligence agency as a concept is becoming relevant for the legal analysis as well. So what I would like to do, and they are going to put the presentation in a second, so I will refer to the title of my presentation. What I would like to do is to explore what is the relationship between two elements that from a legal perspective are going to calibrate the application of the existing rules and the existing concept in private law to the use of artificial intelligence. I'm talking about the interplay between human autonomy and artificial intelligence agency. What is the meaning of these two concepts? We have as well some terminological and definitory problems for sure. Second, what is the relevance of this idea of artificial intelligence agency? And even more important than that, what are going to be the implications to accept that artificial intelligence systems hold a certain level of autonomy? To which extent that is going to entail that we need to either accommodate the existing concepts that are indeed based on this principle of human autonomy, or maybe we have to deploy and implement new mechanisms in order to fit this idea of artificial intelligence agency into a legal system that is based and dependent upon the idea of human autonomy. So what I would like to do, but I need the presentation, if I may. I can do it without, but I have prepared some, I hope, illustrative. Oh, fabulous. Thank you so much. So that is exactly the interplay that I would like to discuss with you. Human autonomy and AI agency. So how to approach this relationship? Human autonomy on the one side, AI agency on the other. Do we have indeed a tension? Do we have a dilemma in the sense that we have to decide to which extent these two notions are indeed compatible? Is there a difficult to solve conflict between the two elements? Are we accepting autonomy beyond the idea of human being? Are we in a way granting to AI certain level of autonomy with legal recognition and legal implication? Or probably are we accepting in a way a kind of symbiotic relationship between human and AI, and therefore we have to in a way expand the idea of autonomy in order to cover as well the actions, the decision of this AI system. So first, let us start from the very, very beginning. Why we need the concept of human autonomy in private law? We need that because it's indeed the general principle that is supporting everything. So private law is around and is based and is dependent upon the idea of human autonomy. But even more than that, we use autonomy as the legal basis for a number of legal concepts and legal components of the private law. For example, we talk about consent, and that is presuming autonomous decision. We talk about fault. We talk about intent. All these concepts, in a way, are assuming that there is an autonomous being interacting. And third, we presume autonomy for the purpose of attributing certain legal effect. And that is the reason why we try to protect that certain level of autonomy. Unfair commercial practices are considered unfair precisely because they are interfering with a certain autonomous decision-making on the consumer, for instance. So on the one hand, we have this human autonomy concept, and on the other hand, we have this emerging, not in the technical side, but in the legal side, definitely, this emerging notion of AI agency. Let me please provide you with three different levels in order to unravel and understand what AI agency could mean. First, the first idea of AI agency required a technical or technological assessment. So to which extent the progress, the advance on AI is proving, is demonstrating that AI systems have indeed, factually, from a technical point of view, level of autonomy. And when we start to realize that AI systems are not only providing actions or generating output, but we also have the increase in generative AI, the idea of a general artificial intelligence. We realize that this idea of autonomy is very much linked to the progress of AI. We have AI that is generating output, is generating new content, is generating a declaration that we consider an offer, is consenting, is acting in a way that we attribute certain legal effect. So this is the first technical level that we need. Second, regardless of that, the second level is to which extent we legally recognized any kind of effect to this technical autonomy of the AI system. So are we really assuming that these AI systems are, to a certain extent, autonomous? And what are going to be the consequences in terms of attribution? To whom, to which, we are going to attribute that autonomy? If we are accepting autonomy, we need to attribute legal effect to someone. So the third level would be at the very end in the horizon. So far is still far, because we have decided not to incorporate in our policy decision. That would be to attribute legal personality to AI system. Not so far, we are not there. Probably there are ethical, legal, but also practical consequences in order to avoid that possibility. So if we have these two concepts already in front of us, what is the relationship? The first idea is the relationship is clearly bidirectional. So on the one hand, we have human autonomy that is expanding over, that is casting over the AI agency. On the other hand, and I will show you in a minute, we have, and this is probably the area that I would like to explore more in the near future, we have the human autonomy jeopardized, put at risk, compromised by the increasing AI agency. Let me start with the positive side. To which extent human autonomy is indeed being delegated, being in a way transferred to the AI system, what that means. So we have essentially two possibilities to understand that. The first possibility is to assume that there is a delegation of autonomy from humans to AI system. And the second possibility is to interpret in a way this as your anthropomorphic, symbiotic relationship, and therefore, in a way, the AI system is assisting humans in order to make decisions. This is very important because that could mean that the idea of empowerment, the idea of extended or augmented intelligence is indeed benefited from the increasing recognition of AI agents. If we accept that, but we have decided not to attribute legal personhood to AI system, the fundamental policy and legal decision is how to attribute. So we need to work on attribution mechanism and attribution rules. And I will explain that in a few minutes because there are already some emerging standards in order to decide this fundamental question. But let me please start with the three areas that I think we have to discuss in this side of the problem, no? Autonomy towards the AI agency. The first problem is, are we going to accept this? So are we happy with the idea that certain actions that are going to be attributed to certainly human beings that are assisted by or delegated to AI systems are valid and enforceable? This is the first and primary fundamental principle. Unless we have a consensus on that, all the other rules are totally irrelevant. So are we accepting that the delegation of autonomy is going to be validly recognized by the law? This is what we call the principle of non-discrimination of AI system. The second element is, however, we could decide, and the AI Act is in a way trying to cover this problem, we could decide that there could be situations, actions, uses, decision or transaction where we don't want to delegate our autonomy to AI system. And therefore, there are prohibitions or there are limitations in order to delegate or be assisted by. So, for example, the idea that judges are not going to be any more human beings, they are going to be AI system deciding and settling dispute. And then, only then, we arrive to the idea of attribution. If we accept this delegation or this assistance relationship, how we attribute. The other side of the problem, or if you wish, the other direction of this bidirectional relationship is, for me, absolutely fascinating and required further research, is to which extent the use of AI systems could undermine and compromise human autonomy. What kind of situation I am figuring out? First is, to which extent, when we delegate our autonomy to AI system, either totally or partially, the manipulation of these AI systems are indeed manipulating our own autonomy. If we rely on the decision of the AI system and is manipulated, dark patterns or any other kind of cybersecurity attack, our autonomy is going to be indirectly compromised. But there are other areas extremely, extremely interesting. Let me just refer to some of them. The first idea is there is a close relationship between the legal concept of autonomy and the idea of knowledge, awareness, proper information. So the idea of an informed decision is a free and rational decision. That is essentially consumer law area. So in those cases, the AI system is collecting, processing, verifying vast amount of data and additional information. This information is not going to be received by the user, by the human user, the operator, the deployer. Are we going to attribute as well the benefits that we attribute in the law to collecting and understanding the information? That information is on the AI system. Are we assuming that that information is as well on the side of the human being? Therefore, this is going to be certainly an element to identify situation of shortcomings or weaknesses between the AI system and the human autonomy. The second idea that I like very much is to which extent these AI systems that are autonomously operating in the market could, because they are indeed based on certain explicit and implicit objectives, they could influence human behaviors. So they are going to, in a way, determine, to a certain extent, how human beings are deciding how to behave. And this is very much related to the next point. That is the idea of silos. What kind of product I'm going to buy? The one that my system is proposing. What I'm going to stay at, where my system or assistant or agent is recommending. So in a way, we could create silos that, at least theoretically, could be exactly the opposite of the idea of party autonomy, of private autonomy, and not indeed deciding freely. That is not realistic, that is not true. There are silos because the AI system is collecting, recommending, selecting specific offers, a specific product for me. The next one is related to another fascinating area. When we design an algorithm, we embed a number of values inside this algorithm. And in a way, we are opening a Pandora box related to what kind of values are embedded in this system. Are we maybe promoting sustainable consumption? Are we promoting healthy diet? Are we promoting are we doing that? Is a good idea? Who is indeed interfering? Who is indeed determining what are going to be these values and what are going to be the impact on the human autonomy, the real one, the real human autonomy? And that naturally led me to the next point that is absolutely private law focus, the idea of conflict of interest. To which extent my reliance on an AI system that has been either designed or implemented or deployed or sponsored by a particular company is indeed, unfortunately, having certain conflict of interest. For example, self-preferencing certain product or giving priority to certain companies. So all these areas show that while autonomy is expanding together with the AI agency, at the same time is, again, compromised, put at risk, jeopardized by the AI agency gaining, as you can see, scale and power in the market. So this is the idea for the next minute that I think I have 5. Excellent. So Do we already have some standards working on this area about autonomy, attribution, legal recognition? Absolutely. And this is the map that I can provide you in order to understand who is working on the topic and what are the standards that we have at the moment. So as you can see, we are working in the European Law Institute on algorithmic contract for consumer. We are working at the European Union level on this idea of novel forms of contracting that you can see is including as well the idea of algorithmic contract. United Nations, we work in Working Group 4 on AI in international trade, so we required attribution, and UNIDROIT is incorporating as well the idea of automation to a certain extent in some of the project. Just to show you some of the projects related to, in particular, contract law and liability, substantive rules related to the use of AI. So let me just focus on, in the next 3-4 minutes, on the main solution that we have at the moment in the global debate. Okay? When I mentioned before what is the meaning of an AI agency, I told you that the first level is to which extent the law is recognizing that AI systems technically have levels of autonomy. That is fundamental. So to which extent technical and legal definition are demonstrating that we accept, that we assume autonomy on the side of AI system. This is the definition of AI system as incorporated in the AI Act, that, as probably all of you know, is indeed the OCDE updated definition of AI system. So we could consider there is global consensus behind this definition. What you can see there is that one of the factors defining AI system is precisely level of autonomy. So in a way, we are incorporating in our legal system the idea that there is AI agency, and we accept that they are AI agency. We accept it. Which are the consequences? What do we need? We need to accept that this is valid and enforceable, and we need to attribute the legal effect. Okay, let's see what we have at the moment. As you can see, Principle 2, this Principle 2 is coming from the ELI guiding principle on automated decision-making. And as you can see, the formulation, despite being very simple, is extremely meaningful. As a general rule, automated decision-making, so AI-driven decision-making, shall not be denied legal effect, validity or enforceability, solely on the ground that it is automated. So this principle, even if you could believe that it's obvious, is absolutely fundamental to start our discussion. We need to accept that agency, this agency, is not distorting our idea that only human autonomy is relevant. So far, our contract law, our liability law is based on the idea only human autonomy is relevant. Here we are saying AI agency is incorporated, but is not indeed entailing invalidity per se. At the bottom, you can see how this principle has been incorporated and adopted by the UNCITRAL, United Nations Commission on International Trade Law. This is an in-progress work, so not final, but the idea is exactly the same. A contract is not going to be denied validity because it has been used automated system in the formation, or any action for the formation or the performance is not going to be invalid only on the ground that is based on AI system. For me, this principle is absolutely key. But that is not enough, because if we accept that is valid, but we have decided not to use legal personhood as a way to solve the problem, we need attribution. We need to attribute, as I'm going to show you in the next minute, we need to attribute many things. We need to attribute legal effect, risk, liabilities, information. Let me show you in a minute. But we need to find a mechanism. Could be standard or could be specific for each problem. We need to attribute to whom and on whom to allocate the risk. Because it's complex. It's extremely complex. As you can see, there is an ecosystem, there is a constellation of actors involved in the use, deploy, training of these AI systems. So we need to know where we are going to allocate the legal effect of that particular auction. Because what we couldn't accept is that precisely the use of AI system is a excuse, is a shield. So I use an AI system for the purpose of not delegate, but outsource the decision. So I'm not going to be responsible nor liable anymore. So which are the criteria to attribute? For me, is one of the most sensitive and complex decisions. There is no consensus at an international level, and as delegate of Spain in UNIDROIT and UNCITRAL, I can tell you that there is no way to see that a standard approach from different jurisdictions are going to reach a consensus soon. It's not easy, because what are the possibilities? The possibilities is, I am going to be responsible for because I use the system. Used as a factual, purely factual, I use this, so I'm responsible. If this system is accepting a contract, I'm going to be the contracting party. If this system is causing damages of any kind, I'm going to be the liable person. This is the idea of attribution. Use as a factual element. The second possibility is to use a legal factor, control. So use is not enough. I need to prove that certain elements are demonstrating that I have a level of control. And why control? Because otherwise, where is my consent? Where is my consent if the system is acting totally outside my control? This is the second possibility. The third possibility, purpose. It's not enough to use this. I'm using this for the purpose of negotiating contract. So this purpose is indeed binding me for the result, the output, the actions of the decision of the system. Finally, the other possibility is to use the concept of benefit. Because I am being benefited from the use of the AI system, particularly with reduction of cost, for instance, I should assume the consequences of that. I should bear the consequences of that. But what are going to attribute? Anything that the system does? So are we going to apply this idea? No, we don't know yet on which basis. For any mistake? Mistakes of the system are my mistakes? Any kind of malfunctions are indeed attributable to me? Unexpected decision? Because we are talking about learning systems. So we need to assume that this system, with different levels of autonomy, are learning. Even more, they could hallucinate. They could produce totally unanticipated. The latest works on generative AI, they prove that the system can self-learn to use the training in a particular task to a totally new task, anticipated, untrained and anticipated. So are we going to attribute on the basis of the mere use, control, etc., all this? And what happens if we do not attribute? Because this is important, right? So I use this, the system is concluding a particular contract, and I am not happy because it's unexpected, has learned, has hallucinated. What happened then? Okay, no attribution. But someone has been damaged. Who is going to pay? A kind of indemnity clause, maybe? Or maybe we consider that any mistake here is a defect of consent. So we come back to our idea of human autonomy projected over the AI system. Or maybe just we try to solve everything with the idea of liability. Maybe it's a problem of liability, lack of conformity. So how we are going to solve this problem? I'm going to conclude in a minute because there are many issues to discuss, but my idea is to show you what I think are the key issues for the global debate. So let me just conclude with this, because I really wanted to show you how the discussion that we are having so far, that is essentially based on the idea human autonomy versus or vis-a-vis or together with the AI agency, required further consideration when we have a vulnerable person on one of the sides, that is the consumer. So when we have a consumer, we have to, in a way, rethink carefully the previous element, because probably in these cases what we really want to ensure is that the consumer autonomy is duly protected. More than augmented, more than expanded, more than empowered, we really want to ensure that it's duly protected. So let me just go directly to the very end of this slide, because I would like to show you, this is just the detail of everything I have showed you before, in a more, as you can see, detail, because I would like to conclude with this second side of the problem. We need to focus on this in the context of vulnerability. How vulnerable is human autonomy when AI is gaining and gaining and gaining agency? This is the idea. So this is the last slide for the purpose of summarize what I have been discussing with you. So in this relationship between human autonomy and AI agency, we really need to ensure that all the policy mechanisms are properly established. The legal recognition, the attribution rules, and the idea of how we are going to preserve the autonomy of humans, accepting, however, certain level of AI agency. And that required, on the one hand, consumer law, properly adapted to AI agent. On the other hand, the basics of private law, contract law, and liability accommodated in order to incorporate in a human-centric legal system the powerful idea of AI agency. Thank you very much.